Order in the court. Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on our docket today is Onewest Bank versus Palmero. The counsel for petitioner is now recognized.
Good morning. If it please the court, Bill McCon of the Law Office of William McCon, along with Jonathan Morton of K.L. Gates and Joshua Thedcraft of Burr Foreman, we represent the petitioner. The issue before the court this morning is who is the borrower in this transaction. The note, the loan agreement, the loan application, the applicable loan documents, all are signed by Mr. Palmero and all define Mr. Palmero as the sole borrower. Mrs. Palmero executed a document called the non-spouse borrower authorization, where she acknowledged that she was not a borrower. And she did execute the mortgage on a line that states that she is a borrower. After a full trial, the trial court determined that Mrs. Palmero was not a borrower. The sole borrower was Mr. Palmero. On appeal to the third DCA, the initial panel, in a decision authored by Judge Robert Luck, determined and affirmed that ruling by the trial court that
Counsel,
Mr. Palmero.
I'm sorry. I just want to go straight to the note. The note contains the following language. If, quote, a borrower dies and the property is not the principal residence of at least one surviving borrower, unquote. If your argument is right and all the transaction documents reflect a deal in which the borrower was singular, how do you deal with that language in the note that acknowledges that the likelihood or the possibility that there would be more than one surviving borrower?
I believe what the note is defining is the rules that apply to a reverse mortgage. It doesn't become due until there is no longer a surviving borrower residing in the home. I don't think there's any question the note defines Mr. Palmero as a borrower and is executed solely by Mr. Palmero. So that triggering or acceleration clause that you referred to, Your Honor, is the same one in the mortgage. And that is why we're here, and that is the issue. If the court were to determine that Mr. Palmero is the sole borrower, then the trial court and the initial appellate court are correct, and petitioners entitled to a final judgment of foreclosure.
You concede, though, for the purposes of the background federal law that allowed this mortgage to be insured. First of all, I guess we should establish you concede that Mrs. Palmero continues to reside at the property. Is that right?
To my knowledge, correct, and certainly as of the time of the trial, yes.
Do you also concede that the transaction wouldn't have happened? That is, the mortgage would not have been insurable had she not executed and participated in the reverse mortgage documentation?
That is not correct. She did not need to participate under federal law. There were single spouse borrower insured loans for, I'll say, approximately 7 years, if not more. That is why she signed. That's the very reason she signed the document designated as a non-borrower certification. It was not required under federal law at the time this loan was originated that both spouses be borrowers. That regulation came in, I believe, 2014, some 7 or 8 years later. In addition, the federal rules and federal statutes pertaining to the insurance loan are between HUD, FHA, and the lender, not between the borrower and the lender. And there are several cases we cited that says, including one out of the 11th Circuit Federal Court, that says these federal statutes simply do not apply to the relationship between a borrower and lender, only between HUD and the lender.
If that's true, then why did she sign the mortgage?
She signed the mortgage for two reasons, Your Honor. The first being she is a spouse. Under Florida law, a spouse must subordinate his or her interest in the property to the mortgage lien under Florida's Constitution. And that is why the spouse executes mortgage initially. In this case, she also had a remainder interest. And so she signed for two reasons. I point out to the court that the children also signed the mortgage because of their remainder interest. And no one has ever argued that the children are borrowers in this transaction.
Can you explain how federal law applies in this circumstance?
It does not apply at all, would be our position. The federal law is regarding the insurance of the loan between the lender and the government. And by the way, there are non-insured reverse mortgages in existence. It's the only reverse mortgages are not insured by HUD. So it does not apply. As I said, I point to the court of the estate. Bear with me for a moment.
Was this loan not insured?
To my knowledge, it was an insured loan.
Or doesn't federal law apply certain conditions to the provision of the insurance for the mortgage?
Absolutely. But that only applies to whether or not the lender is entitled to that insurance. It doesn't apply to the contract between the borrower and the lender. And I also, as I pointed out, the federal government was not enforcing that provision for 8-10 years. There were single spouse borrowers on insured loans for a long period of time before the government finally passed a regulation. Well, after this loan was originated.
What would happen if these same facts occurred today? In other words, I'm trying to understand if there's a real need to continue to try to address the facts of this case under the current state of the law.
Well, I think there certainly is for several reasons. First of all, there are many loans like this loan that were originated during the time period I'm speaking of. But more importantly, the concepts that the third district refused to apply, the mutual construction doctrine, and that you must read the note and mortgage together. This doesn't exist solely in the reverse mortgage world. It applies to all notes and mortgage. I will point to the court that the concept of a non-recourse loan did not originate with reverse mortgages. It's been in existence for decades. And in fact, we cite two cases in our brief that were non-recourse transactions, just like this transaction, where the courts applied the mutual construction doctrine and the doctrine that the note mortgage must be read together. That's Policastro versus Rutt and McVeigh versus Mirabito. So the importance of this case is not limited to reverse mortgages. The ruling by the third district was, we're not going to look to the note because the mortgage is recorded. We're not going to look to the note because the mortgage is the document that the lender is proceeding under. There's no case anywhere that says we're going to apply the mutual construction doctrine to a recorded instrument only, or we're going to apply the mutual construction doctrine to the document that just happens to have the remedy in it.
Let me go back to my question earlier. If application of the federal law as it stands today, would your client be able to foreclose now with the current state of the federal law?
It would not be a federally insured reverse mortgage, is the way I would answer that. Yeah, they could deny insurance and proceed with foreclosure. There is nothing about the federal statute or the federal regulation that governs the relationship between the borrower and the lender. But you are correct, Your Honor, that the insurance would not be available
Is it
today.
Counsel, is it in these reverse amortization mortgages, is it a common practice to have the husband and the wife sign as borrowers in the mortgage? And then the note says something else that exclude one of them as the borrower? Why do you do that? Was
Look,
this a
no.
mistake?
If you look at, for example, the Levine case, that is where a reverse mortgage, I'll say, properly was executed because it designated that in that case, Mrs. Levine was executing it as a non-borrowing spouse. So
It says the mortgage, and right here, the last page, it says Robert Palmero, borrower, Luisa Palmero, borrower. Why do you do that? Did you have to do that to effectuate this transaction?
absolutely not.
Why did you do it? Or why did they do it?
She had to execute it because she was the spouse and had a remainder interest. The mistake was the line it was signed on a pre-printed form that said borrower. But if you looked at all the transaction documents, the note particularly, there's no question the sole borrower, as found by the trial court, as found by the initial panel, was Mr. Palmero. So if you took that position of the third district to its full extreme, if a witness to a mortgage happened to sign on that line marked borrower by mistake with their name there and they signed it, according to the en banc opinion of the third district, that witness is a borrower as a matter of law. And that simply is not correct.
Counsel, can I ask you, I'm sorry to interrupt you. Just in terms of the broader implications that you talked about with the mutual construction doctrine, I think in this case, the mortgage itself has an ambiguity in it because it defines only the husband as the borrower, and then there's the signature at the end. So in that sense, it makes it an easy case for looking at all the other documents. But what if the, and I know that this isn't this case, but I'm just curious about, because you said that that there was this broader kind of legal principle in play. If the mortgage itself were unambiguous, that it defined both people as the borrower, let's say the signature block is the same way it is now, but in the beginning where it was defining the term borrower, it had both people. And then all the other documents were inconsistent with that. What does that just create kind of a fact issue, or would we say that the mortgage itself kind of stands alone and that we would just look at that? How does the mutual construction thing play in if those had been the facts?
Well, I first of all agree with your position that the mortgage is ambiguous and is there. I would secondly say ambiguity is not required for application of the mutual construction doctrine. No, in all the cases we cited in the brief, there was no ambiguity. But to answer your specific question is I would hope that the court would look to all the documents, because to look at one document it creates a bad result. If you look at all the documents in order to determine the intent of the parties, especially in this case.
Counsel, isn't it the case that the mortgage refers to the other documents? And it's kind of contingent upon the operation of the other documents. The note.
And that is correct as well. The same acceleration clause that we're working under here, that the third district said precondition hadn't been met, is in the note and is in the mortgage. Yet in the note, it's unquestionable that the borrower is Mr. Palmero. In the mortgage, at least according to the third district, there becomes this issue because Mrs. Palmero signed on the line designated as borrower, notwithstanding that she didn't sign the note loan agreement and signed a document called the non-borrower spousal certification.
Well,
So,
Counsel, is it possible to enforce the mortgage without the note?
No, the mortgage is solely a security for the underlying obligation created in the note and in the loan agreement. And that's the premise of the century-old rule that the note and mortgage must be read together. They're one contract. They're not two separate contracts. The court has held this is one agreement. They must be read together. And there are numerous cases where the note said one thing, the mortgage said another, and the court said the note controls for obvious reasons. Without a note, a mortgage is kind of like an empty vault. It serves no purpose. So I
Counsel,
believe
you are now about to go into your rebuttal time. You've got 30 more seconds before you get there.
if there's a question at this time of the court, I will try to answer it. If not, I'll reserve the rebuttal time. Thank you.
Thank you. Counsel?
Good morning. May it please the court. Jeffrey Hearn from Legal Services Greater Miami on behalf of the petitioner Luisa Palmero. Reverse mortgages are different, unique financial instruments designed to keep elderly homeowners in their homes. By their own terms, reverse mortgage notes state that the lender may only enforce its terms by enforcing the security agreement against the property. So it takes the normal relationship between a mortgage and a note and turns it upside down. The mortgage is the instrument that controls. And that fact alone makes reverse mortgages distinguishable from this court's prior precedent about the note controlling over the mortgage. The other issue in this case
But counsel, I mean, isn't it still the case, even in this context, that the mortgage can't be enforced without the note?
The note, correct. The note has meaning. It sets the balance of the loan and who can enforce it. The holder of it can proceed with the foreclosure. But that's it. When we're looking at the acceleration clause, which is paragraph 9 of the mortgage, you notice it doesn't even reference the note in that paragraph, and it references the borrower. The borrower is a defined term in both the note and the mortgage. And the Crickle case says that we give effect to both instruments when we can. So if you look at the note, it says that the borrower is who signs at the bottom. That is Mr. Palmero. As I said before, the note by its own terms says that it can only be enforced through the mortgage. And we go to the mortgage. At the top of the mortgage, it has a definition of borrower. The lender chose to include all mortgagors as borrower. It's not just Mr. Palmero. Otherwise, it would say Mr. Palmero, borrower, and then include the rest of the mortgagors. But it didn't do that.
Counsel, if let's just playing a thought experiment. If the signature block said instead of borrower under her name said remainderman or spouse, are we still here?
She's in the definition of borrower, and I believe so. Of course, that's a different fact pattern, a little bit closer to ambiguity, but the definition of borrower is clear. She is a mortgagor, and she signed the mortgage, and the lender chose to define all mortgagors as borrowers. And it's comparable to the Sonderquist case from the 2nd District Court of Appeal and the Greer case from the 4th District. In both of those cases, the courts were enforcing an acceleration clause. And in those mortgages, the mortgage itself said the mortgage is going to control over the note. Well, that's just sort of the inverse of what we have here. The note is saying the mortgage is going to control. That's how the lender is going to enforce its rights. And to recognize that there can be distinctions, even the loan agreement recognizes that. On page 406 of the record, paragraph 4.1 of the loan agreement recognizes that there can be acceleration under one or more of the security instruments. And what that means is that the line of credit that's available to the homeowners is cut off upon Mr. Palmero's death. But the lender cannot foreclose, cannot enforce its rights under the note until all borrowers are deceased or no longer living in the property. Borrower is unambiguous. It's a defined term. If we look at this, the precedent, if you look at the Travelers case that's cited in the briefs, In that case, the court was trying to interpret the meaning of the word accident in an insurance policy. And in both the majority opinion and one of the dissents points out that the term accident is undefined. You look to the Denny case from this court. In that case, pollution was the term. It was a defined term. And what the insured was trying to do in that case is exactly what the lender's doing here. They're trying to rewrite a defined term. And
counsel, I'm sorry to interrupt you, but I mean, at best case scenario for your position, this thing at the beginning is ambiguous as to whether it's referring to all of these people as borrower. And especially when you read it, I mean, seems like you're trying to have it both ways, because I mean, to me, the more natural reading of the beginning is that there's one borrower, i.e. the husband. But even if you think that maybe all these people are considered borrowers, then you go into the signature block and these other folks who you are calling borrowers didn't sign as borrower, which would create an ambiguity, which would then require you to look at all the other stuff. Putting aside, I understand that your colleague on the other side, their position is you just inherently have to look at all the documents together. But even if we wanted to try to look at this one thing in isolation, it seems like it's inescapable to conclude that there's that there's an ambiguity here, that the document isn't internally consistent.
Well, I would suggest that if only Mr. Palmero was the borrower, the term would come immediately after his name. Paragraph 9 suggests.
Does that mean that your position is that the children are also borrowers?
No, that issue has not been advanced by anyone in this case.
No, but I'm asking you, I mean, I don't see how you can read this and say that it's not referring solely to Robert Palmero, but is referring to Luis Palmero too as a borrower, but not the other people that are listed in the clauses that follow Robert Palmero. I mean, the mortgage is given on this date. The mortgager is Roberto Palmero, a married man, and then it goes on and lists the others in their relationship to the property and him. So how can you look at that text and say that your theory is that the husband and wife are borrowers, but the children are not? I'm not following that at all.
Well, that's in the definition. I do think the facts are different if you're looking at ambiguity for purposes of the children and Ms. Palmero. The lender pre-printed her name and wrote the name borrower underneath. And perhaps, there was no testimony at trial about the intent. So all we have are the documents themselves, which this court has said is the best evidence of the party's intent. And the lender chose to include her name as well as the term borrower. And perhaps that is because of the background.
The children's names too in the same manner as her name, correct?
Not on the mortgage itself. In
the first paragraph, you said that borrow was a defined term in the first paragraph, correct? That's your argument.
Yes.
And that your position is that first paragraph defines both Roberto and his wife as borrowers, but does not define the children as borrowers. That's your position?
No, my position is they are defined as a borrower. There may be more ambiguity created by the last page of the document, but there's no ambiguity in that definition. All of those individuals are included in the definition of borrower.
Okay, so the bargain that was struck here, according to you, is that the lender could not foreclose as long as any one of those people, any one of the four, was remaining in the house.
Potentially, but as I said, no, we have not advanced that.
It is or it isn't. I mean that.
Well, that's what the definition of borrower is. The mortgage paragraph 9 says that you can't foreclose until all borrowers are no longer living in the property.
Mr. Hearn, if Mrs. Palmero was a borrower, why did she fill out a, quote, non-borrower spouse ownership interest certification?
There was no testimony about that at trial. The trial court initially ruled that it was inadmissible and then cut off testimony. And for several reasons. One, it's undated. It's unclear that it was signed contemporaneously with the rest of the documents. It's not signed by the closing agent to indicate that. And I think even more importantly, it's not incorporated into the documents. If you look at paragraph 26 of the mortgage, if this was the critical document, which would show the party's intent, the lender could have incorporated it into paragraph 26 of the mortgage, but it chose not to do that.
So you don't dispute that it's in the record, but you throw some shade on it.
Exactly. It should not be given any weight. And clearly, even under the mutual construction doctrine, it doesn't meet one of the documents that we would look at because it's not of the same. I think the J.M. Montgomery case talks about contracts of the same dignity. This clearly is not of the same dignity as a mortgage. And looking to this document, and this is what the third district's en banc opinion said, is that we're not going to look to this questionable document to then redefine a party to a recorded instrument, a mortgage. So I mentioned before, we go to mutual construction if there is no ambiguity. And in fact, in this case, the trial court did not find that there was an ambiguity in the mortgage. It sort of worked backwards. It started with the non-borrowing spouse certification and then moved to the mortgage itself. No court has the trial court did not find that there's ambiguity. We look at the case law that's cited in the briefs, like the J.M. Montgomery case, which petitioner puts on, includes in its reply brief. In that case, it was what ventilation meant. And it was a contractor-subcontractor dispute with the city of Miami. So the court said it was okay to look at another agreement entered into with another subcontractor. Essentially, there was a latent ambiguity. And I think the Denny case explains that you can have, you can't create latent ambiguities that are going to change the express terms of the contract. And the example they give is the greenhouse on Pecan Street and the goods being delivered to a greenhouse, and there's two houses. That is not the situation we have here. We have the mortgage that says that the lender can only foreclose if the borrower is living in the property. We look, Mrs. Palmero is living in the property, look to the definition of borrower, she's a borrower. Therefore, they can't foreclose the security instrument.
Could you explain how federal law applies in this case?
So we can see that Ms. Palmero cannot enforce the federal law. The courts there are doing, that what they did is they said that statute says that HUD shall insure mortgages. So that's a dispute between HUD and the lenders. But I think where federal law comes into play is that it shows that this interpretation is reasonable and that it's consistent. It's not absurd. It's consistent with the intent of the federal policy that had been in place. Petitioner is correct that there were loans that were insured by HUD during this period where there were younger spouses taken off. But that was, HUD has fixed that. The regulations were inconsistent with the statute, and that has been corrected going forward since 2014. I think it's also important to note that this is a fact pattern that is very limited, that lenders did write mortgages differently. If you look at the cases that are on pages 6 and going on to 7 of the reply brief down into the footnote, these are all reverse mortgage cases where they found the surviving spouse was not a borrower. Those fall into two distinct pools that are different. So a lot of them, the surviving spouse was not even included in the definition of borrower. Some of them weren't even on title. And then the other group of cases, you find that the lender did it, at least did something on the face of the mortgage to designate that the surviving spouse was not a borrower.
And I think that goes to some of the questions we've had about the economic realities behind the transaction. One of which is Judge Emis right in his dissent that Ms. Palmero received a larger payout because she was not a borrower under the instrument? Is that, as a matter of just factual record, do you dispute that, or is that right?
So the trial court did not allow in, the lender attempted to put in some figures. So there's no specifics in the record. But generally speaking, yes, there would be a difference. But I think it's important to note that there's nothing in the record that suggests that the Palmeros were desperate. They weren't trying to stop a foreclosure. And in fact, there was equity. If you look page 458 through 460, you'll see that they took out draws on the line of credit of a few $1,000s a couple of times.
You know, my question doesn't go to their desperation or anything. It goes to what really is, like, what's the economic benefit, like the why that Justice Polson was asking you about earlier, right? Or Justice Labarga asked you, you know, like, why was it that this ambiguity in the definition of borrower exists? Is it plausible to say that one reason why it exists is because it the Palmeros stood to benefit from having Ms. Palmero have non-borrower status?
It is plausible, and I think the amicus points out additional issues around incentives for lenders and brokers as well. But none of that is in the record on either side. So we're just sort of going off pure speculation over what the intent was. You know, Sir Mr. Palmero cared for his wife and wanted to ensure she was safe as well. But we don't know what happened. There was no testimony at trial about that, about the transaction.
So counsel, on the federal law point, you know, I don't think that your argument just looking at the four corners of the mortgage is that great, but I mean, do you agree that once you look outside that document, whether you're looking at federal law or looking at these other related agreements, the note and everything else, I mean, isn't that pretty much fatal to your case once you start looking out beyond that?
I don't think so, because I mean, you clearly show that your initial loan application had Ms. Palmero on it.
I mean, but the application, the revised application that led to the actual transaction that occurred, I mean, there's no dispute that that was just by the husband, right?
Correct. That was the second loan.
And your client signed the, you know, non-borrower spouse thing and it just seems like if you look outside this document, the evidence is overwhelming that there was only one borrower. Do you disagree with that?
Borrower, and as our position is, the borrower is under the note, and the borrower for purposes of when can the lender foreclose and enforce the security instrument is a separate analysis. I think it's important to note that the petitioner is arguing that there's sort of a floodgates issue here, and that is not the case for two of the reasons mentioned. As we said, this won't happen again. HUD has ensured that people like Ms. Palmero will not lose their home going forward to ensure that surviving spouses are protected. Additionally, as those cases in the reply brief on 6 and 7 indicate, lenders often wrote it differently. And when they did, it might create an ambiguity for which the courts then could go to these additional documents. And the idea that parties can come to the court later and say, look at these other documents to redefine a party to the transaction. The only other document that Mrs. Palmero signed is this questionable certification. And that cannot be relied upon to change the very party to the transaction. That would lead to uncertainty and unnecessary litigation, or if we allow parties to rewrite who is the party to the contract. And so I'd just like to conclude that we're asking this court either to dismiss the case for lack of jurisdiction because there's no conflict, or alternatively to affirm this court's, the third district's decision en banc opinion. Thank you.
Thank you, counsel. Rebuttal.
First of all, on the issue of ambiguity, with all due respect, 3 courts have visited this issue prior to it reaching this court, and 2 courts have ruled that she's not a borrower. 1 court has ruled she is. I suggest to the court that the term ambiguity is that it can be reasonably interpreted in more than one way. The borrower, the spouse, Mrs. Palmero, signed the non-borrower certification for a very clear reason. Under the program, and the testimony is in the trial, The Palmeros received more funds by designating Mr. Palmero as a sole borrower. And that's on the record at 520 to 532, and again on 556. The Palmeros actually received about 24,000 more in additional funds by designating Mr. Palmero as the sole borrower. And that's why originally the application was by both of them. 4 months later, after receiving counseling, and there is a certification of counseling in the record, they determined that they would be able to receive more funds by designating Mr. Palmero as the sole borrower. This program of reverse mortgage is very important to the elderly. This funds in this mortgage paid off 2 existing traditional loans that existed on the property. The elderly typically don't have the income to pay monthly payments. So the program allows them to take their assets, in this case, their home, and eliminate or relieve them of the obligation to pay those monthly payments on the 2 existing mortgages that were paid off. And this was intentional by the Palmeros. It's a benefit. They got the benefit of the bargain. They negotiated it. And now they want to change the benefit of the bargain to extend this loan. And the question was asked about the children being a borrower. Well, the children could not be a borrower under this program because of their ages. You don't qualify until you're at least 62.
It seems like, Counsel, it seems like you're trying to apply the definition in the note, a document that she did not sign, instead of the definition in the mortgage, a document she did sign. Why should that be?
Well, we're here to determine that very issue, who the borrower is. The fact that she did not sign the note is proof that she was not a borrower. And so it's a little bit.
The right to foreclose as described in the mortgage, the document that she signed and is obligated under, not the note, a document she did not sign.
She's not obligated under this program in any way, shape, or form. She signed the mortgage as she's required to do under Florida law. And this would be the case if it were a reverse mortgage or a conventional mortgage or otherwise.
Could the program have gone through, or could the loan have gone through had she not signed
the
mortgage
program? Theoretically, the program could have gone through. Realistically, the mortgage would have been enforceable against the property. And since the lender had agreed, that was its sole remedy. And understand, the lender's taking the risk here that depending on how long the party survives and what the appraised value of the property is at the time, they're taking the full risk and providing these funds to an elderly couple so that they're relieved of the monthly payment on the existing mortgages. So when you say could it have gone through, there would not have been an enforceable lien under Florida's Constitution, but for her signature and also because she held a remainder interest as the children did. So they needed to subordinate their interest in the property to the loan. They are not a borrower. There's no concept that being a mortgage.
Counsel, you are now in overtime, so if you could sum up in about 30 seconds.
We are requesting that the court quash the decision of the third DCA and enter a determination that the petitioner is entitled to a final judgment of foreclosure. Thank you.
Thank you. We thank you both for your arguments in this case today, and the court will now prepare to take up the second case on today's docket. The court now will take up the second case on our docket, Suzuki Motor Corporation versus Winkler. Counsel?
Thank you, Your Honor. May it please the court, Raul Cantero on behalf of Suzuki Motor Corporation. I'm reserving 5 minutes for rebuttal. The issue in this case is whether in a products liability case against Suzuki pending in Jacksonville, Florida, the plaintiff may examine the chairman and former CEO of Suzuki in Japan, who has no knowledge of the case or the circumstances leading up to it. We submit that regardless of whether this court adopts the Apex doctrine, it should quash the first DCA's decision and hold that there was no evidence that the examination of the chairman would be likely to lead to the discovery of relevant evidence.
Counsel, I'm sorry to interrupt you. Could I ask you about this declaration? It seems like, you know, obviously as a matter of common sense, I can't imagine that Mr. Suzuki knows anything about this particular accident. And the declaration is very clear that he doesn't remember anything about this document that was shown to him. But the declaration doesn't say that he doesn't know anything about sort of the overall recall decision with this, because obviously this issue with the product had to do with more than just this one accident. So, you know, what are we to make of that? I mean, it does seem like there's a difference between this case and these insurance cases where it's very much focused on, you know, the one dispute and the high level official says, I know nothing about this coverage dispute or whatever. It seems like here it would be plausible to think that Mr. Suzuki, regardless of whether he had authority to make the recall decision or anything like that, it does seem plausible that he might have information that could lead to admissible evidence as to just the overall sort of corporate decision making on this issue in a broader sense. And it doesn't seem like the declaration precludes that.
Your Honor, we need to look not only at the declaration, that's certainly one thing, but also Mr. Kudo, who was with Suzuki Motors America, was deposed in this case over a period of 3 days. And he testified, and his deposition is in the record. And that was the relevant parts are at RA Respondent's Appendix 557 to 571. And he testified that the only entity that can make a decision on recall was the Quality Countermeasures Committee. That Mr. Suzuki was not on that committee. He had no authority on the committee. He cannot override or veto on the committee. And that it was the chairman of the committee who ultimately makes the decision. Mr. Kudo was involved in the investigation. And in fact, plaintiffs introduced an expert, and that expert affidavit attached 23 different exhibits to the affidavit, and that you can find at Respondent's Appendix 221 to 394, so 170 different pages of documents. In those exhibits are emails either from Kudo or to Kudo. He was intimately involved. The expert identifies Kudo as having made a cost-benefit analysis, and that's at Respondent's Appendix 358 to 61, where he has like pros and cons of issuing a recall. Mr. Kudo was intimately involved with the decision, as you can see from those exhibits. In addition, during the pendency of the petition in the first DCA, they deposed the corporate representative for Suzuki Motor Corporation. I say deposed as they deposed him, yes, as corporate representative in Japan, again over a period of 3 days, who corroborated what Mr. Kudo said about the authority of the Quality Countermeasures Committee and about the lack of authority of the chairman to be involved in recall decisions. In fact, they testified that it was a policy of the company to kind of cabin off the chairman from any decision about the recall so that the committee is completely independent and can decide on its own whether to issue a recall without any veto or involvement of the chairman. So yes, there is the declaration, and he says in fact, in his declaration, he says, I would have no authority to override, reject, or even order a field action or recall. So
I
we
guess
have,
but all of everything you just said, I mean, it goes to the authority to make the decisions as opposed to just knowledge about how the company decided to handle this. So can I ask you a question though about the standard of review? So the departure from the essential requirements of law, you agree and you concede in the briefs that there is no existing sort of black letter apex doctrine that Florida court, it's obviously nothing in the face of the rules themselves. And as far as case law, there's no sort of black letter rule that would apply an apex doctrine in the corporate context at this point, if we just take the law as it stood at the time that this court was having to decide this. That's right?
yes.
Okay. So then does that leave you with sort of an abuse of discretion argument? I mean, how do you get to the departure from the?
I think, well, this is how I get there, Your Honor. And let me just talk a little bit about two cases from this court. The first is Martin Johnson versus Savage, which I'm sure you're familiar with, which even back then in 1987 said that discovery orders have been traditionally reviewed by certiorari. So even 33 years ago, this court considered it a tradition that discovery orders were reviewed by certiorari. Second, in 1995, Allstate versus Langston quashed a district court order. And I want to quote what it said. It quashed the district court's opinion, quote, to the extent that it permits discovery even where it has been affirmatively established that such discovery is neither relevant nor will lead to the discovery of relevant information. Subsequently, other district courts of appeal have taken up that language and have held in discovery orders where there is no extant law, no case on point, but we do have the rules of procedure, which also are established law. As courts have said, it's not just a case on point, it could be a rule on point. And district courts have reversed discovery orders where the discovery was not reasonably likely to lead to the discovery of admissible evidence. When that happens, then there's a departure from the essential requirements of law.
Basically, because under the circumstances, you would say that it seems so unlikely that it would, or it's so clearly shown that the deposition or whatever the discovery wouldn't lead to the discovery of admissible evidence, that it's an abuse of discretion not to enter the protective order. I mean, isn't that essentially what the court would be concluding?
Yes, except I think couched in the language of a departure from the essential requirements of law, which courts have equated in the discovery context, abuse of discretion with such a departure. And there have been cases that have done that in this very context. In fact, as I'm sure you know, we cited General Starr versus Atlantic Hospitality from the 3rd DCA, which also quashed in the corporate context. And I think you referred to it earlier, Justice Muniz, in terms of the insurance context, where the president was set to be deposed. He had no knowledge of the case. The 3rd DCA quashed that order because it was not reasonably likely to lead to the discovery of admissible evidence. So it did so without adopting the Apex Doctrine. It said we don't have to issue so broad a ruling in this case when we can simply apply the rule.
And in terms of what's at issue substantively in this lawsuit, isn't one of the claims sort of going to kind of what the corporation knew about the alleged defect in the product and the decision to recall and the related decision of whether to warn and all that? And isn't it plausible that Mr. Suzuki could know about those things? I mean, he certainly doesn't disclaim knowledge of it in the declaration.
Your Honor, if we needed the president of a company to testify about the company's knowledge every time there was a case, then there would always be the president of the corporation being deposed.
Right.
What you need is a corporate representative.
Right. As a policy matter, I'm very sympathetic to what you're saying, but I think that for better or worse, it seems like there's two paths that you have. One would be sort of a kind of addition to the normal rules of discovery in the form of an apex doctrine that would sort of say, notwithstanding the fact that, you know, if we just look sort of in the abstract at what you're allowed to discover and whatever, sure, you could go to the CEO, but we're going to say as a matter of law that essentially to cabin trial court discretion, they have to require parties to start somewhere else first. But if we don't have that here yet, and if we're stuck with just sort of the basics of discovery, even if there are better places to get the information, it doesn't seem like the rules require you to go to the best source of information from the get-go. I mean, or the failure to require you to do so is necessarily an abuse of discretion. I mean, is that not a fair characterization of where we are?
No, I don't think so, Your Honor, because in that event, then in Florida, a multinational corporation's president, CEO, chief operating officer would be deposed in just about every case, because it's hard to believe they will not receive documents and just be informed, FYI, of things that are going on in the company without being directly involved in what's going on, without having any decision-making authority, what's going on. They just need to be informed about what's going on. And then that would just eviscerate any kind of protection that high-level officials would have over depositions, because you will always find a reason why a president may have to be deposed, just like they did in this case. If you are correct, Your Honor, then maybe the president of General Star Insurance Company would have been deposed in that case. Here, we identified for them, and that's at RA 699 to 702, I think it was 24 different members of the Quality Countermeasure Committee over the tenure that's relevant in this case, which is roughly 2012 through 2013, 17 members at any given time. They have never sought to examine any of the members of that committee. The people identified in the email, the email came from one manager.
I'm sorry to interrupt you. If one question I have is, if we were to agree with the idea that it is sort of a per se abuse of discretion to not have the apex doctrine in place, how broadly is it your position we should be adopting the rule? Is it to the singular CEO of the global enterprise? Or, for example, of those 17 members on that committee, would any of them be covered by the apex doctrine in your estimation?
They would not, Your Honor. I think that the apex doctrine traditionally has been applied to officers and directors of the company. So the C-blank-O of the company, COO, CEO, CTO, CIO, the general counsel, members of the board of directors, the chairman of the board of directors. I haven't seen it applied to anybody other than that. And when you go below that, then it's likely that they would have knowledge, may have been directly involved. So I think the likelihood is much greater. The way also that the court can adopt it, in which happened in this case and in the Atlantic Hospitality case, is the proposed deponent or the party that is contesting the deposition must first come forward with positive evidence that this official doesn't have knowledge. And then the party seeking the deposition would have to show that this person has unique knowledge that nobody else has and that is necessary to prosecute the lawsuit.
It's like the argument that you're making about sort of the practicality. And again, I'm very sympathetic to it, but it seems like even if Mr. Suzuki remembered the memo, there would still probably be 500 other people at the company who would know a lot more, and who you, as a matter of policy, you would want the information seeker to depose first. So it just seems like what you're asking us to do. And again, and to Justice Coriol's question, it seems like the harder it is to even define what the apex doctrine is. I mean, obviously this would be an easy case if we had an apex doctrine because he is the CEO, but it seems like the more vague the rule itself is, the harder it is to say that it's a per se abuse of discretion not to follow a rule that we don't even, that one can't even really clearly define.
Well, and that's why some of the cases from out of state that they have cited, while they do not adopt the apex doctrine per se, they still reversed orders requiring the deposition of the apex official under the circumstances of that case. And that's what the third DCA did in General Starr. That's what the first DCA did in the Haberger case with the university president. And that's what this court can do is, and as I said, you don't have to adopt the apex doctrine. You can say that in this particular case, the examination was not reasonably likely to lead to the discovery of admissible evidence. And I see that I'm running into my rebuttal time. I know the Chief Justice is about to warn me, so thank you. And I'll reserve the rest of my time for rebuttal. Thank you.
Thank you. Counsel?
Thank you. May it please the court. Shay Moxon on behalf of the respondent, Scott Winkler. I came prepared today, ready to start talking about jurisdiction, apex doctrine, but I find it interesting that the petitioner's argument skips right over all that and wants to go straight to asking this court to directly reviewing the trial judge's discretionary decision on a discovery ruling where he weighed the evidence that was presented to him, the documents, heard the arguments of counsel, and he made a factual determination that this examination of Osamu Suzuki is likely to lead to relevant evidence. As a matter of fact, he even found that he is uniquely able to provide relevant information. And so the whole,
what would be the basis for thinking that he's quote unquote uniquely able? I mean, obviously everyone has unique information in the sense that they have their own sort of personal perspective, but it seems like there's enough in the record here to assume that, he only would have the same sort of kind of observational type information that countless other people in the company would have.
Well, as Your Honor recognized earlier, this is a decision concerning whether and when to initiate a recall that was discussed at the highest level of the company. And so Judge Salve was considering what the email and memo showed and concluded that Mr. Suzuki was at least involved in this decision to initiate the recall. And so there is relevance beyond his mere status as a chairman. And in some of the decisions that we decided, like Bridgestone, Firestone, Travelers v. Ford, even in jurisdictions that apply some version of the apex doctrine, when there are issues of knowledge or motives at the highest levels of the company, that's when it becomes appropriate to examine top officials who may have knowledge about those matters.
So given your failure though to even try to get information from all these other people on this committee who would obviously have a lot more sort of useful facts for you and information to lead to other things, I mean, why wouldn't this be sort of the classic case where you could infer from your failure to do that, that really the only reason why you're so relentlessly pursuing this is because to harass this potential deponent in the company?
Well, Your Honor, that whole issue of whether we should have or why we didn't try to depose members of the committee, that was never developed out on the record. So I'm at a bit of a disadvantage to discussing that without going outside the record a little bit. And as a matter of fact, the claim that we didn't try to depose him, I mean, even that's not fully developed on the record. One interesting fact that I discovered preparing for this is that Mr. Kudo, whose deposition Mr. Quintero was just discussing, in his deposition, which was taken, the third volume, which was taken just a month before we initiated this process, he was asked, when did the Quality Countermeasure Committee, when did they first become informed of this? And his answer was October 11, 2013. That was the first time that committee knew about it. And so, and that's just by way to show that there's a lot of confusion about who we even would have known to depose. So at that point, this is just about 5 months before a trial judge enters his order, we're being told by Mr. Kudo that this committee didn't even know about this brake problem at the time. So there's just one fact in the whole picture of it. My understanding is that there are discussions between counsel behind the scenes, and we were led to believe that Suzuki was not going to consent to any deposition taken through the normal process at the embassy unless it was a corporate representative deposition. Tie that all in with the fact that any deposition taken in Japan takes months to set up, costs many thousands of dollars. It could run up to about $10,000 per deposition. All the burdens are discussed in the two cases I cited, J.C. Renfro and Sons and the Shaw order from November 17th, or excuse me, November of 2017. All just to say that, there's a very complex factual and procedural background to this. So one of the reasons I've asked the court to discharge jurisdiction is because this is such an unusual case where we don't have normal deposition procedures where anyone can just issue a notice and then the CEO either has to sit for deposition or there's a protective order. And then, trial judge can say, well, why don't you just depose some of these other people first? And you say, okay, I go do that. I mean, that's completely impractical here, where every single deposition is going to have to go through letterrogatory. There's going to be fights over the translation of the letterrogatory. That's going on now, as Suzuki pointed out in their reply brief. Things have to be set up months in advance. And, if we had a whole hearing where we could have developed, an answer to this question, well, why haven't you done some quality control countermeasure committee depos first? We'd have a whole record about that. But, I'm asking the court to step back, though, and look, what is its role here? This is where I started out with. Suzuki is asking this court to step in and directly review Judge Saud's finding of relevance based on the factual background of this case and the information, the evidence he was presented with. Judge Saud drew his, he reached his conclusion that there's relevant material information to be had here, and Suzuki disagrees with it because they think other evidence points in the other direction. That respectfully is not what this court is here for. That review was already held by the First District when they considered Suzuki's petition for certiorari and concluded that there's no departure from the essential of the requirements of the law.
Well, but they're also asking us to try to lend some coherence to Florida law overall, which is our role. And why should the head of DBPR have more protection from a potentially, harassing deposition request than, the CEO of a company like this? I mean, it does seem, so could you address that? I mean, so obviously the cases have talked about government agency heads, but in terms of the underlying principles that led to the development of that doctrine, it seems like it would be hard to argue that those same principles don't apply in this context.
Well, there are two key distinctions in the government context. First is that the decisions that adopted this, a variant of the Apex doctrine in the corporate context, government context, were driven largely by concerns for separation of powers.
Isn't that really, though, more relevant to what that courts talk about that in the context of the types of questions that can be asked in sort of discretionary government decisions? But it seems like the core of the doctrine originated with the idea that, if you just literally look at our discovery rules, you could theoretically come up with some reason why you could depose an agency head for pretty much anything that's going on in the agency. And it seems like, as your colleague on the other side was saying, the same argument is, what you're making in this case in the corporate context.
Well, respectfully, Justice Muniz, I have to disagree. There is actually, I reviewed all the government Apex cases recently, and there's not one mention of any rules of discovery in there that I could see. Just maybe a casual mention that somebody moved for a protective order. Now, the doctrine originated with out of concern for the separation of powers. Going back to the HRS versus Brook case, 573 something second 363. That case was addressing more trial testimony, but then in later decisions, the first district applied the same principles to depositions. And again, it was same concern, largely driven by a concern for deposition, separation of powers, where agency heads were being brought in to ask to explain their reasoning behind discretionary decisions or how they would have behaved, ruled in hypothetical situations. So there's a separation of powers concern that's not present in the corporate context. And then there's also a public policy matter, which is that those cases are all driven by also by a concern that if agency heads are subjected to too many depositions, that it would deter qualified people from wanting to seek those positions in government. Well, there's no public policy that drives courts to try to encourage employment as heads of private corporations. That public policy concern just isn't here. And that's one of the reasons why the Citigroup case and Florida Office of Insurance Regulation said that that the private context is distinguishable, that we don't have that public policy concern.
Well, that's pretty, I mean, I think, you know, look, I think the more you talk policy, the weaker your position is. I mean, I think sticking to sort of the black letter existing laws, I mean, because it's really, it seems indefensible that you could have sort of one policy for an agency here and a policy that acts like we should be indifferent to, you know, potential, you know, harassment of people who are, you know, similarly potentially involved in everything that goes on, you know, literally in this case, all over the world.
Well, I can only offer why those courts adopted that government apex rule, which has never been before this court. Before this court has never really weighed in on that, whether that was correct law in the first place. But those government context cases, they're not based on any rules of procedure. Their origin are in the separation of powers concerns and this public policy of encouraging employment, neither of which applies here. What we do have in the corporate context, the private context, we have a set of rules that there's absolutely no way to discern in the text of any of these rules any basis to give special treatment to top officers of corporations when somebody wants to take their deposition. There's nothing in there that puts any burden on the person seeking their deposition to have to make this unique showing that the deponent will have unique knowledge that nobody else has, and that they've exhausted every other source of discovery. You know, the version of the doctrine that is phrased in this question, it would require exhaustion of all other discovery, even if the apex official has unique knowledge, which, you know, doesn't make sense. If it's unique knowledge, then why exhaust everything else? But so, you know, there's no basis in the rules, and really this doctrine is unnecessary. Yeah, at one point where I think we agree with Suzuki is that existing rules are sufficient to address this supposed problem, if it really is a problem, of potentially harassing depositions of CEOs and chairmen of the board. We just disagree on how that applies to the facts here. So my point being is that the current rules provide trial courts with all the tools they need to prevent harassing depositions and to make sure that you know, the wheels of commerce aren't going to be ground to a halt by calling every CEO and chairman in to sit for deposition over and over, and to make sure that the depositions are going to be reasonably calculated to lead to admissible evidence.
But
So
aren't the facts here sort of the poster child for why maybe there should be more guidance for trial courts? Because really, it seems like the only thing that you're hanging your hat on for why there should be a deposition here is this, you know, the fact that this piece of paper was shown to this guy who probably sees a gazillion of these memos. And so there's nothing, you know, so to the extent that there's nothing in our rules that prevent that, then it seems like maybe there does need to be more meat on the bone of what the rules are.
Well, it wasn't just that it was shown to him, but it was discussed with him. It was discussed with him, and reading the email afterwards, the email indicates that the managers involved with that document are apparently needing his signature for whatever purpose. The email says, today, when I handed the background material for the senior managing officer explained it to the chairman, came back with the chairman's signature. I'm sending the material with the signature. So they were waiting for his signature. Despite what he says about not having authority to approve it, it really doesn't stand to reason that whatever he might have thought or said when he reviewed this, that would be ignored by the company. And it would certainly have weight at trial. But again, I want the court to step back and, this evidence, it was weighed by the trial judge. He made this ruling. It's a discretionary ruling, and it's already been reviewed once by the First District Court of Appeal that found no departure from the essential requirements of the law. And so how does this case get up to this court? Well, they certified this question of great public importance, but the question that Suzuki would like that to be, whether this court should adopt the Apex Doctrine, that's not a question that the First District ever passed upon. So it's a fundamental principle of this court's jurisdiction under Article 5, 3B4. It doesn't have jurisdiction to answer questions that were never passed upon by the district court. And so here, the First District, they never weighed the pros and cons of extending the Apex Doctrine to the corporate side, never canvassed the cases around the country from different states, some adopting, some rejecting, examine whether it's consistent with the rules. So that question that Suzuki was, has been asking this court to answer until they seem to change course today, that whether this doctrine should be adopted by this court, that's not a question that was ever passed upon by the First District. And so
Judge Thomas spent some time talking about it, didn't he?
Well, he certainly did, but a dissent is not. Yes, he did, but the court has to look to the majority opinion because the court reviews the decision that passes upon a question certified by it to be of great public importance. So it has to be passed upon by the.
In this case, there's no question the court passed upon the question that it certified, which is it a departure from the essential requirements of law, ... So that means that's the gateway to jurisdiction. And now your colleague on the other side has asked us to review the decision. And we're being asked to decide, is it a departure from the essential requirements of law? And it sounds like he's basing his argument on some, broader principles here that at least there is some hook in existing Florida law. So I don't think that regardless of how we should answer the question, it doesn't seem like it's not properly before the court.
Well, I submit that the question of whether this doctrine should be adopted is not properly before the court. What the First District.
Be helpful if I'm in mute. Where in the question, counsel, is the word should?
It's not in there, and that's my point.
They're asking us. They made a decision that there was not a violation of the essential requirements of law, and they're asking us to address that same question, whether they were right or wrong on that question that they addressed. I mean, whether this case ought to be discharged for some other reason, that's a different question. But on that. Just how they didn't pass on what they've actually asked here, I'm mystified by that.
Yes, that actually wasn't what I was arguing. What they actually wrote, what the certified question actually asked, and what they passed upon is whether the Apex Doctrine is currently law. Everyone in the corporate context, everyone agrees that it isn't. Suzuki agreed that it isn't at page 3 of the reply brief. And so looking at it that way, it's a very simple matter. You can either discharge jurisdiction because it's already settled and you don't even need to answer it, or you can just say, no, it's not currently law in the corporate context. And so there's no departure from the central requirements of law and failing to apply it. You did the right thing, First District, by denying certiorari because there was no violation of a clearly established principle of law. There's definitely no clearly established law extending this very rigid apex rule to the corporate context. It's been either rejected or declined to be applied in every district court decision that's ever looked at the question. And I know I'm running low on time, but just to sum up, we maintain there's no jurisdiction to answer the should question because that was never passed upon. Beyond that, this is the wrong case because the unusual procedures and the specific factual context to really decide whether the apex doctrine should be adopted. The doctrine is unnecessary because current rules already give trial judges enough discretion to deal with any problem of potentially harassing depositions when they arise. And if the court were to consider whether to adopt this very rigid rule that greatly limits discovery in every case involving corporate policies, that would best be done in a rule proceeding. And so in conclusion, we're asking the court to discharge jurisdiction. Failing that, it should answer the certified question in the negative and approve the First District's opinion. Decision denying certiorari.
Thank you, counsel. Now for rebuttal argument.
Perhaps working my way backward, unless the court has any questions. As to the certified question, the first certified question asks, does a trial court depart from the essential requirements of law by not requiring a party seeking to depose the top officer of a corporation to show that one, other means of discovery have been exhausted, and two, the corporate officer is uniquely able to provide relevant information that cannot be obtained from other sources? There can be no question that both the majority and the dissent address that issue. That was the whole point of the majority and dissenting opinions. So I don't think there's any question that the court does have discretionary jurisdiction. And I also submit that the court should retain jurisdiction and answer the question or any rephrased question because of the policy issues involved and to eliminate any incongruity between the protections that an apex public official receives and an apex private official receives. Let us remember that as far as public officials, their role is important, but it's restricted to the state of Florida. For apex officials in the private corporations, as is the case here, their influence is worldwide. Suzuki operates in many parts of the world. And so I submit that the state should protect those officials at least as much as it protects public officials. So that's a reason to retain the case. On the merits, I'd like to address, Judge Muniz, you referred to the black letter law. We have Rule 1.280B1, I believe it is, which requires that the discovery be relevant or reasonably likely to lead to the discovery of relevant information. This court and other courts have routinely, historically, traditionally reviewed discovery orders on that basis. It quashes discovery orders regardless of whether there was already a case on point. In the discovery context, if you need there to be a prior case, you probably would not decide 90% of discovery petitions for certiorari because they always involve unique, new factual circumstances. And so the courts do not say, is there established law on point? In which case, rarely will a trial judge violate it. It asks,
I understand what you're saying, but it seems like we either you know, in order to sort of justify our kind of intervening here, you could imagine a quote unquote adopting an apex rule, which is sort of a, you know, kind of it would be essentially a new rule. Or if we're really just, if we really were just going to say that, you know, given, you know, this declaration and what, you know, the corporate rep in this case said that, you know, this particular person's deposition, you know, there wasn't enough there to conclude that it would reasonably lead to the discovery of admissible evidence. I mean, that would be, I mean, would you agree that that would be kind of an odd thing for this court to be getting, to be essentially issuing a micro ruling on something like that?
It is unusual, but not unprecedented. And I submit that that's exactly what this court did in Allstate versus Langston. It's kind of what it did in Elkin versus Sykin, where it adopted the third DCA's 8-point plan, so to speak, for getting a financial discovery and other discovery from experts in a case. That was a case of first impression here. But I think more broadly, the court should clarify, is there an apex doctrine in Florida? Because courts are applying it to public officials. And if there's an apex doctrine, should it apply both to public and private officials? I don't think the court should, I think it has the opportunity.
But you concede, counsel, that if we make that declaration, it will be the existence of an apex doctrine that applies in the corporate context. That will be newly discovered. It will be something that we have just discovered in this case.
Well, I don't think it's, in a sense, it's newly discovered. I understand what your point is, but it's the application of the rules of procedure, the Rule 1.280B1 and Rule 1.280C, which allows courts to issue orders to prevent annoyance, embarrassment, oppression, or undue burden or expense to particular facts that may arise and standardize the process, like this court did in Sykin versus Elkin. So I don't think it's new, but to the extent it is, it's certainly not unprecedented that this court creates new standards when a case first appears before it. It's done it before, as we said in our brief with Tucker versus Resha, with Sykin versus Elkin.
Well, it just seems like it seems to me, and I'll say this, that it's kind of an odd thing to have a newly discovered, clearly established principle of law.
Well, the clearly established principle, Your Honor, is the rule itself that prohibits discovery that is not reasonably likely to lead to discovery of admissible evidence. And that's
I apologize for talking to you here, and once your rebuttal time is over, if you could sum up about 30 seconds.
Certainly, Your Honor. Thank you for the indulgence. We submit that the court, whether or not it adopts the apex doctrine, should quash the decision of the District Court of Appeal and hold that either under the circumstances of this particular case or in other circumstances that the deposition of or examination of an apex official should not be taken until the party can show that only that official has unique knowledge that is unavailable from other officials. Thank you very much for your time.
All right. We thank you both for your arguments in this case today. And before the court moves on to the rest of our docket, we will now take a recess of about 10 minutes. The court will now consider the case of Smith versus the state of Florida. Counsel for the appellant is recognized.
Richard Kurtz on behalf of Donald Smith.
Thank you, counsel. Please proceed.
Thank you so much, Your Honor. Unlike the previous cases, I wish I was handling mortgages and it's a Suzuki case, but I'm handling a very horrible set of facts and that I would like to submit to the court. So I would like to discuss with the court the inflammatory nature of this prosecution with the pretrial media, with the comments made by the prosecution, as well as the medical examiner crying on her testimony when she's the chief medical examiner who had 1,000 medical or autopsies under her belt, and the closing arguments. So my major argument to the court is going to ultimately end with that while either of these items were not reversible on themselves, it's the cumulative effect. And so that's where I'm going to be going with this conversation. So,
Counselor, I would ask, as you're going through, I'm really interested with each of these points where the prejudice particularly lies based on the evidence that was presented in this case. So when you address those points, you talk about how it vitiates the entire trial and is not simply perhaps a harmless error, even assuming these issues were error.
Thank you for asking that question, because that's one of the issues that I've been paying attention to is error, harmless error, prejudicial error. What my suggestion would be to the court is these comments that I'm making to you were so inflammatory that they culminate into prejudicial error. And when you deal with a death penalty case, while some of my issues may be weak, and I'll just say it, some of my issues may be weak, but they culminate. And if you handle enough death penalty cases, as I have, and I've been in front of the Supreme Court many, many times, and I've handled probably 30 death penalty cases and probably well over 50 homicide cases, the culmination of the effect causes a prejudicial issue. And so I was court appointed to handle this case, so I'm doing everything I can to represent my client in the best way that I can. So that's where I'm at with it, and I'm happy to take hard questions. And thank you for being the first one to ask me. I expected Judge Kennedy to bust my chops first, but thank you so much. But I'm happy to discuss anything I can with you. But I believe the culmination of everything with, let me just, here's my breakdown of it. And I was watching everything else that was transpiring and wishing I had a different career choice instead of handling homicides and death penalty cases. The issue begins with the fact that there was so much pretrial publicity and the case was not moved. And then when we get to oral arguments or opening statements, excuse me, and then we led into having a medical examiner crying on the stand, and we had too many photographs.
Did the jury, in fact, ever see the medical examiner cry? I watched the video. It seemed like she paused and the jury was asked to leave the room. Why do you keep repeating that she cried in front of the jury?
I don't know that and thank you so much for asking. I don't know that I'm repeating, but I think it was clear on the record and acknowledged by the court as well as the state that she teared up and the jury teared up, and then she asked for a 5-minute break.
Are you suggesting that the jury tears up, then we have inflammatory situations that require reversal?
Yes, sir.
Anytime a juror tears up, that's the rule you'd have us adopt?
I've handled so many homicides. A juror tears up, it's not it. But thank you for asking me this question, because it leads into my answer that I'm going to have is this medical examiner is done. She's the chief medical examiner. She's handled 1,000 autopsies or more. They did a pretrial motion to exclude all of these photographs, and she did not cry at any point or tear up at any point. The only time she teared up or needed a break was when she was in front of the jury.
Are you, counsel, are you suggesting that was contrived?
No, I know the prosecutors involved in this. I know them both personally. No, I am never going to suggest that was contrived, Your Honor.
And is there some suggestion in the record that there's something going on with the jury, and it might be that her response to what she's seeing in the jury, or is that something that's not supported by the record?
Justice Kennedy, I am not by any means suggesting that anybody did anything improper, like behind the scenes. By no means. I know these prosecutors, I know these defense lawyers. I'm just saying is this happened, and we know it happened, so we have to address it, and that's why we come to you, is because it did happen.
Well, what I struggle with, and I understand you're representing your client, and you're going to do that zealously, and that's your job, and that's the way things work. But this is, as you acknowledged, a tough case, and they're just, when you've got a case like this, some of these things that you're pointing to are just almost inherent in the case. It's just the nature when you have an abduction, rape, and murder of a young child. That's an emotional thing. I mean, it's people may respond with some emotion as that is being explained to them. So it's just, it seems that to some extent, maybe you're requiring us to treat this like that's not the underlying facts. And so I don't know know what you can say in response to that, but I think that's really, to put this in context, and I think essentially that goes back to the question that was asked at the outset by Justice Grosshands. I'm just having trouble. I mean, the other, if you look at your issues individually, for instance, the venue issue. Well, this trial, am I not correct that this trial took place a number of years after the crime had been committed, and furthermore, it's in a large metropolitan area, Jacksonville, and there's the jury was picked, and you don't have any challenges to any of the particular jurors. That you were able to get a jury. So I'm just I cannot see how you piece these inadequate things together and come up with something that matters.
And I appreciate everything you just said, and I cannot concede my client's conviction, but yes, it is an automatic appeal to you, and I have a job to do, and I greatly appreciate you recognizing that. But I also have an obligation to represent my client, and I do believe there are issues that individually will not amount. I'll just say it out loud. I do not believe the individual issues will amount to a reversible error. I do believe that in my argument to this court is that if you take them all together, then we have a cumulative error that would substantiate a reversal. That's where I'm at with it. And I'm happy to discuss each one of them. Yes, there was an overwhelming weight of evidence. I was not the trial lawyer, which I'm typically the trial lawyer, not the appellate lawyer. But here I am trying to do my duty ethically and for the bar. So I'm trying to defend my client. And you make very good points, and I'm happy to take, it's one of those things, Judge. At some point, you just got to take the hard shots. So give them to me, and I'll try to answer them the best I can.
Counselor, I think, we're required to look to see if any errors can be deemed harmless. I mean, we're required to look, like the state has made that argument, and we are looking at that. So how what is your best argument for this cumulative effect of all of these individual things that you've said happen, even if every single one of them we deem was error? You've said there was an overwhelming amount of evidence in this case. And so how do we get past that harmless error analysis?
And very good question. And I was up at 1 o'clock in the morning trying to think about how I would answer this question to you. First, the jury should have been moved. The change of venue should have been done. And I'm looking at my notes, so if I look away, I apologize. The autopsy photographs, the comments by the prosecutor in opening statement, the crying on the stand, and the closing argument where the victim was crying out, and that's really probably my best argument, is where the golden rule violation, where the prosecutor says, and I'll just quote it, and thank you for asking, and it's in volume, and I hate doing this, 1436. And from the grave, she is crying out to you, and she's talking to the jury. And that, to me, personally, is a golden rule violation. And she's crying out from the grave to you. Donald Smith raped me. Donald Smith sodomized me. Donald Smith strangled me until my last breath of my body. And so if you take all of those 4 or 5 things that I just rattled off to you, I tend to think that, in my experience, that the cumulative error of all of those comments by the prosecution and that I think they're legitimate. And
help us understand why you think that's a golden rule violation. If the prosecutor had instead said, and are crying out to you, comma, the finder of fact, comma, would it no longer be a golden rule violation? Because as I understand the golden rule, the idea is to prevent the jury from putting itself in the shoes of the victim or the prosecutor or anyone other than the finder of fact. What is it about this statement that makes it a golden rule violation?
To me, it's one word, the word you. If she said the victim was crying out, that would be okay. But when they say crying out to you, the jury, when the victim is crying out to you, the jury, that's when I personally have a problem.
What's your best case for that being a golden rule violation?
I mean, anytime and I don't have that in front of me, but anytime a witness is putting the juror in the place of a victim, to me, that's golden rule. I don't understand.
Well, I guess my question is, it doesn't seem to me like that's what the prosecutor did at all. It seems like what the prosecutor was doing was, in fact, talking to the jury as a jury, crying out to you. I guess my struggle is I don't understand how that's anything other than an appeal to the jury, as opposed to saying, imagine you are Cherish Periwinkle, which would be a golden rule violation.
Exactly. I mean, I think you just made my point, Your Honor, is that that's what she was doing. She was appealing to the jury and putting them in the place of the victim. And she is crying out to you that he has strangled me, raped me, and sodomized me. I think, Your Honor, maybe I'm having a disconnect, but I think you just made my point. Anyway, the other issues were the photographs. And what the state has argued and what the defense did was that they indicated that they had filed a motion to preclude all photographs from there. But in their brief, they indicated the evidence was so overwhelming that basically they didn't need the photographs, but the photographs were what caused the medical examiner to cry and what caused the jury to cry. So to me, that was additional error. And so that's why I'm sitting here having this discussion with the court. The other thing would be the improper comments during the opening statement and the closing statement by the prosecution. Am I frozen, or can anybody?
Oh
hear?
no, we're just you keep going. If we'll interrupt you if we have questions, we're not shy. You can keep going.
And I know that about you, Justice Candidate. I appreciate it. No, those are my arguments. And normally my wife tells me I talk too long and talk too much, but this is probably my shortest closing argument or argument to the Florida Supreme Court that I've ever had. So I could defer at this point.
All right, thank you, counsel. Counsel for the state.
Good morning, Your Honor. Chief Justice Kennedy, may it please the court. Assistant Attorney General Charmaine Millsaps, representing the state. I take counsel's argument to really be the cumulative error, and then he relies on all the other errors to fold into the cumulative. Of the issues that he's really talking about, only 2 of them were preserved. The pretrial publicity, the presumed prejudice claim based on pretrial publicity, they did not renew the motion for change of venue. What happened there was that they made a motion to change venue years prior to the trial. They made a motion to change venue before the trial in 2014, and there was a hearing on that motion in November of 2015. And at the end of the hearing, the judge said, under Florida law ruling, correctly ruled that I should reserve ruling until we see if we can select a jury in Jacksonville, in Duval County, which, as your honors have pointed out, is a large metropolitan area that is very diverse. So the trial judge, she ruled that she was going to reserve ruling until they actually tried to pick a jury selection. And then February 5th through February 9th of 2018, the trial court here held a week-long jury selection involving questionnaires, individual voir dire, and at the beginning of that jury selection, and remember what the ruling was. The ruling was, I'm going to reserve ruling on your motion for change of venue until the end of jury selection to see if we can pick a jury. Yes, they renewed, the defense renewed the motion for change of venue at the start of jury selection, but they did not renew the motion at the end of jury selection. They did not renew the motion or ask for a ruling either at the end of jury selection or next day when the jury was sworn, or when the jury started. That was February 12th, when the trial actually started. So there is no ruling from the trial court on the motion. So that is not preserved. That is being raised as a claim of fundamental error. The prosecutor's comment about crying out from the grave was also not objected to, and that's not preserved, and that would also have to amount to fundamental error. Now, regarding cumulative error is really the claim that 2 or more errors, which are subject to harmless error, while harmless individually, are not harmless together. First of all, on this evidence, we have both DNA from the victim's neck, DNA from the victim's vagina, DNA from the victim's anus, all of which match the defendant at extraordinary numbers. We also have a videotape of the beginning of the kidnapping. The Walmart security cameras show Donald Smith leaving Walmart after he told Cherish's mother that he was going to go to the McDonald's inside the Walmart and buy them all hamburgers because they hadn't had dinner. but the surveillance camera shows him leaving the Walmart at 10:44. So the prosecutor's comment, this you cannot consider either the pretrial or the prosecutor's comment as part of a cumulative error. Fundamental error cannot be included. Cumulative error is a cumulative harmless error analysis. So you would only do the issues that were preserved in it, and those two are the photographs and the medical examiner. So I'd like to talk about those two because those are the only ones that can possibly be part of a cumulative error analysis. A motion for mistrial when the medical examiner, who incidentally did indeed testify at the motion to exclude the photographs and had no trouble going through all of the photographs. The prosecutor, after the medical examiner hesitates and asks for a recess, she says, "I just need a break." She is not audibly or visibly crying. But once the trial court grants the medical examiner a recess, we're all going to take a recess for 10 minutes. The jury leaves, and after the jury leaves, there's a discussion between defense counsel and the prosecutor. The prosecutor explains during that discussion that some of the jurors who were looking at the autopsy photographs became emotional, and some of the jurors looking at the autopsy photographs were tearing up. That's from the prosecutor's explanation in his argument in response to why the motion for mistrial should be denied. So what's happened?
Ms. Millsaps, did the defense seek a curative instruction?
They specifically declined. They said no curative would cure this. They kept insisting she was crying. That's just not in the record, Your Honor. But the trial court is in the best position to understand what is going on, because the trial court is seeing the jury as well as the medical examiner. The trial judge, she is closest to the medical examiner, can see in much more detail than we can from the video. So you should defer to the trial court. The trial court did not make a finding that she was crying. The trial court just granted the recess. And then defense counsel kept saying that. The prosecutor disputed it, explained really the only tearing up that was happening was in the jury box. Your Honor, and the state openly admits that these autopsy photographs of a heinous, atrocious, and cruel murder are heinous. They are hard to look at, and they're hard to look at for people who are lawyers who've tried these kinds of cases before. Remember, many of these jurors looking at these autopsy photographs of a 8-year-old child have never seen anything like this before. So, but Your Honor, the judge that was there, who could really see the entire courtroom and had a better view, denied this mistrial. And really the only thing on the record was the ME asking for a break. Have never seen anything. So the state's position is the granting of the motion for mistrial was not error at all. And remember, under cumulative error, you have to find error, denied this mistrial. 2 errors that you then decide, while harmless individually, are not harmless together. So denying the motion for mistrial is not error at all. It certainly did not vitiate the entire trial. Taking a 10-minute recess for the ME to compose herself is not error, much less vitiate.
Ms. Millsap, let me just bring up a point. I've been bringing this point up to cases like this since I started on the court 12 years ago. and it seems like they don't seem to end. And, you know, and I understand your position. I understand the harmless error rule. I understand all that. I understand the arguments. But again, this sort of things keep happening. We have opening statements. The law is clear. Opening statements, the purpose is to basically give the jury a preview of what the evidence is going to show. The evidence is going to show this. The evidence is going to show that. Yet, during opening statements, the prosecutor injects every mother's darkest nightmare became Periwinkle's reality. I mean, I guess one could argue that's what the evidence is going to show, but that's not what it's intended for. And I understand the harmless error rule, and I understand it wasn't objective to. And nevertheless, it's there. I mean, and it seems to me, it seems to me that these type of statements, these type of remarks, that are not proper, are being made in cases where the evidence is locked. You know, I mean, here, clearly, the evidence is substantial. So why inject these things into a record? Why are we here today having to deal with these issues? And I've raised this issue with other attorney generals before, in the hopes that prosecutors out there just stop doing this and concentrate on just the evidence. Yet here we are again in a case as serious as this, injecting these type of things into the record. And I understand that not much you can do about it. I guess you can call out this prosecutor and tell him, please don't do that again. I don't want to deal with this. But yet it keeps happening. And I guess I'm just making a statement, not asking a question, because I see these all the time. What do you think?
Well, Your Honor, I might understand that. Your Honor, the prosecutor said that every mother's darkest nightmare became Periwinkle. That's the mother of the victim's reality. That's the reality of this case. That is what she was describing, the prosecutor was describing the victim's, the mother's reaction about finding her child was missing from the store, and the person who most likely took her, she had just met a few hours ago at another store.
Yes, and had she made that statement in closing argument after all the evidence had come in, then yes, I agree. At that point in time, it would not have been all that improper. But this is during opening statements where you're telling the jury what the evidence is going to show.
And,
I mean,
and
again, it's just a minor point, but it's just they keep coming. I guess when I tried cases, I was so careful about the record that I did not want to inject anything that would in any way bring any attention to anything in the record, especially when I had a locked case.
Well, Your Honor, I'm not trying to, I don't see anything wrong with this first comment during opening statement. I really don't. And incidentally, neither did defense counsel, because at the start of the penalty phase, defense counsel themselves described this crime as every parent's worst nightmare. That there was no dispute that having a child missing, knowing that that child has been taken by somebody you just met, that's just a description of this mother's reaction when she describes and why she calls 911. And then they hear the tape. So I think that's just the reality. I think everybody knows that reality. So I understand that sometimes prosecutors cross the line, but I don't think that comment crossed the line. That's just, she's just describing why the mother is calling 911, and the 911 call is was played for the jury. And it is every mother's darkest nightmare. So I understand that sometimes prosecutors cross the line, and given the evidence in the case, it doesn't seem necessary, but this just strikes me, I don't see that as error. Regarding the darkest nightmare, I don't see that as error, much less, the basis of the objection to that comment was argumentative. They are now arguing that it's explosive and shouldn't be said. So that's not even the same objection that they made below. So I don't see, if you go down them, the pretrial wasn't preserved. That's fundamental error. You don't consider it an accumulative error. The ME was not crying audibly or visibly, and she did the appropriate thing, which was to ask for a recess. The photographs, the medical examiner took 74 photographs. The state was only seeking to introduce 30, and in fact, we only introduced 28. So there's no error in the admission of these photographs. I'd like to remind the court, the state has a beyond a reasonable doubt standard of proof.
Indeed, Ms. Millsaps, isn't it arguable that for the HAC aggravator, the photographs were relevant to the consideration of that as well?
Absolutely, Your Honor. And the state really only called one additional witness at the penalty phase. So we were using this evidence to establish our HAC aggravator. So Your Honor, when you have a beyond a reasonable doubt standard of proof, and nothing can convey information like a photograph. As a matter of fact, CIS jurors are going to say to themselves, where's the photograph? So Your Honor, it's just inevitable when you have a heinous crime that the photographs of that crime are going to be heinous. But we need those heinous photographs to prove our HAC aggravator, which was found by the jury as well as the trial court and given great weight by the trial court. So yes, Your Honor, that is indeed the state's position, and that's one of the arguments I made in the brief. All right, so and then we've also talked about the prosecutor's comment. So there's no error to accumulate, and even if there was, if you do find two things that you think are error, remember both the DNA evidence and the videotape of the beginning of this kidnapping. So the cumulative error claim should be denied because this is harmless. If you could find two errors, even those two errors together would be harmless in light of the evidence in this case. And the state asks you to affirm the conviction and sentence. And that is the conclusion of the state's presentation.
Thank you, counsel. Now for rebuttal.
Thank you, Your Honor. It was interesting listening to the state giving basically a criminal defense lawyer argument, starting backwards, that the photos were the most powerful. Those were the ones that were actually objected to and were moved to exclude in advance. But then the state argues that the DNA and the video and everything else was so powerful that they really didn't need the videos or the pictures, excuse me. But they still moved them in over objection. And those are the ones that got.
But counsel, we do know that although we've got this, there's law about unduly inflammatory, but we also have the basic rule that it's the rule of relevance, not of necessity. Yes. So the state's not limited to what they absolutely must have. Isn't that correct?
Yes, sir. I concede. Did I lose you?
Oh, no, I'm
Hey, look, I have to admit what I have to admit, okay? So no, I agree with you. I get to concede what I have to concede. It's not my first rodeo. Yes, the pictures under the case law is indicating that they're entitled to introduce those. And then the question becomes, is it too inflammatory? Is it a 403 violation? Or is it, too cumulative? I 100% agree with you. But since the state argued that there were not two or more issues that addressed cumulative error, it's my job as court-appointed counsel to make sure that I address these with you. And that's one of the ones, and you just asked me that question. Next, the state concedes that the jury was tearing up. Okay. The video, whether you can see it or not, I believe the state will concede that the medical examiner was tearing up. Beyond a reasonable doubt, and the HAC aggravator is not applicable in the guilt phase. That would be 100% applicable after they found him guilty, if they did find him guilty. But it was it was during the guilt phase, and there's some level where you have to prove that it was heinous, atrocious, and cruel. But in this situation, my argument would be, to your honor, Justice Candidate, is that that was improper during the guilt phase. I sit here acknowledging the overwhelming weight, but the question is, it's not about did he get a perfect trial, but did he get a fair trial? And that's where I have to sit here and have this conversation with you, Justice Candidate.
Well, if there are no questions and you have nothing left.
I'm looking at my notes, Your Honor. No, Your Honor. Thank you so much. It's good to see you again.
Thank you, counsel. We thank both of you for your arguments in this case that's before the court today. And the court will now prepare to move on to the final case on today's docket.
Thank you.
The court will now take up the last case on the docket, Laboratory Corporation of America versus Davis. Counsel?
Thank you, Mr. Chief Justice, and may it please the court. My name is Kate Stetson. I am arguing this morning on behalf of the petitioners, Sheridan and LabCorp, and I've reserved 5 minutes for rebuttal. The respondent in this case, Patty Davis, filed a class action lawsuit against LabCorp and Sheridan when she received bills for medical treatments that should have been sent to her employer's insurance carrier. Ms. Davis brought that lawsuit under the Florida Consumer Collection Practices Act, And her argument was that because the state's workers' compensation law prohibits providers from billing employees directly for medical treatments, that Sheridan and LabCorp had violated the FCCPA in sending their bills to her rather than to her employer's carrier. But this court recognized some time ago in Sanders versus City of Orlando that the state's workers' compensation law contains a broad exclusive jurisdiction provision. And it's section 440.1311C, which says, among other things, that the department has, and I'll quote, exclusive jurisdiction to decide any matters concerning reimbursement, close quote.
Counsel, let me ask you this. Just a variation on the facts here. Say that this all went the way it went, except that Ms. Davis actually paid the bill. She paid the provider. So maybe she wasn't represented by an attorney and she thought, well, I've got to pay it. And then later she found out that that was wrong, that it was an illegal, the sending of the bill to her was contrary to law, and she sought to get it back. Is there a mechanism for the department to adjudicate her claim to get that money back?
My understanding, Mr. Chief Justice, is that in circumstances where the employee has mistakenly paid a medical bill that should have been channeled to the insurance carrier, that actually goes through the Office of the Judges of Compensation Claims. Because at that point, the employee is essentially seeking a return of money. So that's over kind of in that category of claims. So still,
so that would not, so this matter about the department having exclusive jurisdiction to decide any matter concerning reimbursement would not apply to that.
I think it would not apply to that only because of the breakdown between what the judges of compensation claims have authority over and what the department has authority over. The judges of compensation claims, of course, do have particularized authority over certain aspects of the workers' compensation scheme.
Well, the circuit courts have particularized authority over claims under the FCCPA. Isn't that correct?
I would describe them as having authority over claims under the FCCPA, but just because that statute exists, I think that just begs the question about whether this particular claim exists.
But what I struggle here with understanding how the circuit court can be ousted of jurisdiction under this provision related to exclusive jurisdiction to decide matters that's vested in the department, if it's a matter that can't be adjudicated by the department. It seems like the reference to exclusive jurisdiction would have to be premised on an understanding that the department actually has jurisdiction over the particular matter that is going to be decided.
No, but I'd like to be very clear, Mr. Chief Justice. Ms. Davis didn't pay any money. Her complaint.
Well, I understand that, but it's the same. It's essentially the same question. It's about the relationship of the authority of the department to adjudicate matters that are specifically like a dispute between the provider and the employee, which you've already conceded they don't really have. And when we look, when I look at the statute up in 11A, it contemplates that sometimes a provider is going to receive a payment that they shouldn't receive, but it specifically provides that the healthcare provider has received payment from a carrier for services that were improperly billed, and so on. It must return those payments to the carrier. There's no similar provision with respect to an employee who's improperly billed, is there?
There is indeed, and it's contained in the rules, Chief Justice Kennedy. If you look at the rules that under which the department executes its authority under 440.1311A, exactly the statute that you're talking about, Rule 69L-34.001 specifically defines a violation of this statute as, and I quote, collecting or receiving payment from an injured worker in violation of the statute. Rule 69L 34.003 provides that a person such as Ms. Davis can report a violation of the workers' compensation law to the division's Office of Medical Services. And it specifically identifies as one piece of supporting documentation that that person can attach copies of collection letters sent to the injured worker from the provider or a collection agent acting on behalf of the provider seeking payment for covered medical services. So there's really no dispute, Your Honor, in this case that reimbursement is payment for covered medical services. The only dispute between the parties is whether that word reimbursement somehow attaches only to requests for payment between the provider and
let me ask you another question, and then I'll give my colleagues a chance to ask their questions. But you're talking about reimbursement. Now, let me give you a hypothetical related to the ordinary use of that term. If my daughter, who is away at college, tells me that she received a bill from her physician, and asked should she pay it, I'm not going to say, yeah, go ahead and reimburse the doctor. I might say to her, you can pay it and I will reimburse you. That's the way that term is ordinarily used in that context. So I'm struggling to understand how a payment, a bill from a provider is a demand for to the patient who received the services is a demand for reimbursement, or that a payment made after such a demand would be a reimbursement payment. That just doesn't seem to be the way the English language is used.
I think, first of all, unfortunately, sometimes in the workers' compensation and health arenas, the English language is used in particularized ways, as we know. But second and more important, a request for reimbursement, if we all agree, as we do, that a request for reimbursement running from a provider to a carrier, that bill, you pay me for X, is a request for reimbursement. There is nothing different in quality between that request and the request to the employee. And if
I don't understand that argument at all. So because there's a clearly established sense of this that reimbursement includes indemnification, things such as that. So where there was a third party involved, and that is not the same as a demand for payment from the person who received the services.
Let me try to go at this another way then, Mr. Chief Justice, and I'd refer you to two provisions in particular, 440.13(1)Q, which is the definition of reimbursement dispute. And I'd like you to consider it next to 440.13(3)G. And I'll start with 1Q. Reimbursement dispute means any disagreement between a healthcare provider or healthcare facility and carrier concerning payment for medical treatment. That is the definition of a dispute about reimbursement, a dispute over payment for medical treatment. Turn to 440.13(3)G. The employee is not liable for payment for medical treatment. So in this statute, and this is something that I think actually Mr. Gowdy and I largely agree on, it's just a question of who the X and Y are when you talk about paying X, X paying Y. A reimbursement in this statute is a payment for medical treatment. And if we're going to play the kind of math exercise that Mr. Gowdy does in his brief, we can look at the number of times that a payment to a provider is discussed in the context of talking about a carrier's obligation to pay a provider. So the short path through.
Excuse me, could I go in a different direction and talk about the FCCPA under which this plaintiff sued? You recognize that has a civil remedies provision in it, 559.77, is that correct?
It does have a civil remedies provision.
That
yes.
was the basis for suit, is that correct?
Yes.
Okay. And it says that any person who fails to comply with any provision of 559.72, which defines the unfair debt collection practices, is liable for actual damages and for additional statutory damages as the court may allow, and with a limit, together with costs and reasonable attorney's fees. And then it goes on to contemplate a class action lawsuit. Is that correct?
Yes, that is all correct, I believe.
Okay. And it's clear from this statute and unambiguous, any person that you're client would fit within that. They would be subject to this suit if they, according to this statute, if they violated the terms of 559.72. Is that what the statute says?
There, I think I have to start parting ways with you, Justice Lawson.
I mean, is that what this statute says? Let's not look at any other statute. She's suing under this statute. This statute says any person. Would you agree that it says that your client is subject to suit for this?
I would agree that my client would be any person. I think perhaps where I'd have to start parting ways with you is whether this is a consumer debt, which is not a question that's in this case. The point that I would make, though, Justice Lawson.
But the allegation is that your client failed to comply with a provision of 559.72, correct?
That is correct, and that's exactly the allegation that the plaintiff in Einhorn.
Okay.
Sorry, go ahead.
And the statute says that the court's going to adjudicate this, and you would agree that there's no provision in 440 or anywhere else for anybody other than circuit court to adjudicate action under 559.77, correct?
There is no provision in the workers' compensation law for a court to adjudicate.
No, for anybody else. For the Department of Finance can't authorize the statutory damages, attorney's fees for a violation of the Debt Collection Act.
That's correct, and that's our point. Yes.
Okay, but there's a statute that says that the circuit court can adjudicate that claim, correct?
There is. The general debt collection statute does say that, yes.
Was the plaintiff seeking reimbursement for anything in that action, or was the plaintiff seeking the statutory damages, court costs, and other damages outlined in the civil remedies provision?
In this action, I think the plaintiff was bringing a class action on behalf of herself. And
but was reimbursement for anything an issue?
No, because she.
No, yeah, right, yeah. So why is what the term reimbursement in a different statute means if the plaintiff brought a claim under this act for the statutory damages provided in this act and made all the allegations that this statute says constitute a cause of action for damages under this act?
Because, Justice Lawson, of that broad exclusive jurisdiction language that I mentioned. It says any matter concerning reimbursement. It doesn't say any matter concerning reimbursement where the reimbursement has been made.
Okay,
After all, when you talk
to
about
harmonize the law, harmonize various statutes if they relate to one another?
Yes.
And I'm having a struggle understanding why, when one statute is clear and unambiguous and gives everybody who's subject to an Unfair Debt Collection Practices Act a cause of action with statutorily defined damages against anybody who violates the act, we would be, I mean, it would seem to, if we're going to harmonize these statutes, there would have to be something as express and clear as is in 559, such as a workers' compensation, someone who's subject to workers' compensation benefits cannot take advantage of the civil remedies provision and 559. They just are out of luck and are subject to consumer debt collection, unfair consumer debt collection practices. Why wouldn't a specific exemption be necessary to ignore the plain language of 559.77, which obviously gives a remedy?
For a couple different reasons, Justice Lawson. The first is the workers' compensation law and the exclusive jurisdiction provision, which gives the department jurisdiction over any matters concerning reimbursement. That was in place, excuse me, long before the FCCPA. And of course, this court recognizes and understands the doctrine of implied repeal. There is nothing in the FCCPA that acts to deprive the department of the exclusive jurisdiction that it has over a matter concerning reimbursement, which this simply.
But this lawsuit is a matter concerning an unfair debt collection practice for statutory damages that have nothing to do with the reimbursement or anything related to the workers' comp statute.
Justice Lawson, that is precisely the argument that the plaintiff in Einhorn made. The plaintiff in Einhorn, which we cite at page 25 of our initial brief, brought an FCCPA case against her health insurer, claiming that the health insurer had essentially overshot a lien that it was entitled to under the Medicare Act. And what the court in Einhorn held was that because the Medicare Act specifically channels those types of complaints through an administrative procedure, the court did not have jurisdiction. It lacked jurisdiction under the FCCPA to administer that.
So how does a different statute channel a complaint that your client violated the Unfair Debt Collection Practices Act anywhere other than circuit court?
I think, Justice Lawson, the point that you and I are really joining issue on is that you are framing this case exactly as the plaintiff has framed it. This is
in
a
their complaint under
case.
the statute.
Yes.
Yeah.
Our point is that no matter what label you put on this, you can call it a debt collection case and you can try to bring a claim under the FCCPA, just as the plaintiff did in Einhorn. What this is at bottom is a matter concerning reimbursement, because this complaint is about Ms. Davis getting a bill that should have been sent to her employer's insurance carrier. That is a matter concerning reimbursement.
I'm sorry to interrupt you, and welcome to our court. It seems like your argument, as I understand it, is almost like a preemption argument, and it sort of, you're kind of asking us to read the 11C passage that you're relying on literally. But if you look at the act itself, even just this section where in 5D it talks about the employee may appeal to a judge of compensation claims for reimbursement when the employer or carrier withholds payment. And then in 12, you have this 3-member panel, which is not the department. It's aided by the department, but it's not the department. So within this provision itself, we have examples of other entities making decisions about matters that are, about reimbursement. And so it seems like you're asking us to read the 11C phrase literally, when in the act itself, we know that it can't be read literally and make the act make sense. And so it seems like really the issue is does this case involve a quote unquote decision about a matter, of the type that is exclusively for the department?
Justice Muniz, I think the answer is that while there are instances where a workers' compensation issue is channeled by that workers' compensation statute into a different place, so that you can essentially read exclusive jurisdiction to decide any matters concerning reimbursement with that in mind, because it's within the same statute. The emphasis, I think, should not be on decide. That's never where the parties have joined issue. The emphasis on any and concerning and reimbursement. Any, of course, as this court has recognized many times, means any. Concerning is very broad, and reimbursement means payment from one person to another. That's what the statute specifically says in those two provisions that I read to you earlier, 13.1Q and 13.3G. Reimbursement means payment for medical services rendered, full stop.
Is there anything, so this is kind of a process, sort of who decides thing. Is there anything substantively in the workers' comp law that would suggest to us that essentially, to the extent the department can police overbilling or improper billing and that sort of thing, that essentially those remedies are the only ones available in this kind of context, and that they displace any sort of consumer protection type remedy that might be found elsewhere? Because it really seems like that it's almost like a sort of field preemption type thing that it seems like we would have to buy into to side with you more so than just looking at this language, for the reasons that I laid out.
Right. And first of all, I'm cognizant that I may be eating into my rebuttal time.
Counsel, and you have exhausted it. So, but if you'll answer this question briefly, I will, even though the time's been gone, I'll nonetheless afford you 3 minutes of rebuttal time.
Okay, thank you. Justice Muniz, I think the answer to your question lies in Sanders itself. I don't think that this case is properly described as any kind of a preemption case. That's not the way that it's ever been framed. It's not the way the trial courts address this when they address the issue. It's a jurisdictional case. And as this court said in Sanders, every Article 5 court to have looked at this issue had noted the broad and exclusive jurisdiction provision in the workers' compensation statutes. I don't think you need to do any more kind of magic or math than that. I think the answer lies in the plain text of the statute. When the department has exclusive jurisdiction over any matters concerning reimbursement, and this is a request for reimbursement for medical services, the department has exclusive jurisdiction over it. Thank you for your indulgence, Mr. Chief Justice.
All right, counsel.
Good morning. May it please the court. Brian Gowdy on behalf of the injured worker, Ms. Davis. The key word here is reimbursement. Every reimbursement is a payment, but not every payment is a reimbursement. Just as every poodle is a dog, but not every dog is a poodle. Let's compare reimbursement with other words used for payment. For example, disbursement. The ordinary way these two words are commonly used differ, though both mean a payment in some sense. A disbursement, which in its Latin and French roots meant a payment from a purse, occurs when one party, usually from a fund, pays a second party for goods or services, or to fulfill a legal obligation, or for some other particular purpose. In contrast, the word here, reimbursement, which at its Latin and French roots meant a payment into a purse, occurs when a third party indemnifies a second party for goods or services or a payment that the second party previously provided to a first party. The central flaw in the provider's argument is that based on their own sense of the word and nothing else, they assume that every use of the word payment is a reimbursement.
So what's the sense of the word concerning?
The sense of the word is used
matter concerning.
I'm sorry,
any matter concerning.
Any matter concerning is broad, and I don't think that's where the debate here is.
And you don't deny that the claim, part of proving your claim in this parallel, in the FCC, whatever action, that you would, for part of that would be establishing that in fact, the carrier had the reimbursement obligation and not your client, and the debt collector knew that, and that's what made it improper, et cetera. So I mean, there's no way that you can decouple the reimbursement issue from that claim.
I don't entirely agree. I'll part ways with you partly on that. We clearly are relying on section or paragraph 3G, which says the employee is not liable for payment for medical treatment or services. The problem that my opponent has is she wants to link that use of payment in 3G with how it's used in 1Q, which is where we're talking about a reimbursement dispute. And in that context, in 1Q, it's clearly talking about between a provider and a carrier.
Right, but I think the weakest part of your argument is that even if you accept the narrow definition of reimbursement that you're advocating, the dispute, the consumer collection dispute still relates to that issue. It still concerns that issue. And, there's case law that, that I think is cited in the briefs that talks about how the word concerning is very broad. And so it can, even if the reimbursement is referring to the carrier and provider, it still concerns that at its heart, as it's an essential aspect of it.
Well, I don't think that's entirely true, especially if you look under everything in 559.72, including some of our claims here. And the Chief Justice actually beat me to it with his hypothetical that he started with, where if Ms. Davis had paid the bill and then later learned that the carrier had also paid the bill, the natural thing for Ms. Davis to do would be to go to, if the carrier refused to reimburse her, refund her, I guess I should say, to be accurate, then the natural thing would be a common law claim for unjust enrichment or quantum merit.
Wouldn't the easier thing be to pick up the phone and call the department and say I was improperly billed and you need to get my money back for me? I mean, I think that it's clear that whether this is an exclusive remedy or not, it seems like if you just draw a circle around the workers' comp system itself, the rules and the statute do account for this kind of problem. We don't have to invent a consumer protection law or a common law action to try to fix this problem.
Well, I have lots of other examples that I think will undermine your point, Justice Muniz. Suppose that the provider decided to make to threaten with force for this payment, that would be actionable not only under the FCCPA, but under the common law for assault, or if a battery was committed in connection with it. Those claims are now out too under the provider's reading of 44.1311C.
I understand. And this is where I think it does get to the question of, is this, within sort of the way this statute uses decisions, about matters concerning reimbursement. I mean, one way to look at this is that it's just a sort of garden variety dispute over within the workers' comp system who is supposed to pay. I don't know that we need to get into, hypotheticals about people threatening to beat each other up or whatever that are clearly outside of a workers' comp context to answer or ask the question about, is this the type of dispute that's being referred to in this provision?
But the language that you're giving to it and the providers are giving to it foreclose all these other actions, Your Honor, because you're saying, well, because it's a matter concerning reimbursement, if a provider were to threaten force to collect a payment, an unlawful payment, that would, under the provider's reading, would be a matter concerning reimbursement.
Can I ask you on this? Is there any dispute about who should have paid this bill? Who was supposed to pay this bill? Is that an issue at all in this case, or is that essentially conceded?
Well, I mean, we're here on a motion for judgment on the pleadings. I would hope the providers would concede that. I'd have to go back and review the answer whether they admitted that or not, Your Honor. I mean, it seems the answer should be there should be no dispute, but maybe you can ask my opponent on that. We're very early in this case.
But for the legal question that we're having to answer here, it really doesn't matter because, I mean, there are situations where, for example, if care isn't authorized in advance or whatever, it's not per se wrong for something that could be implicated in workers' comp where there could properly be a bill that would be sent to the patient. And so you really are, you can't get away from the need to kind of, in order to prove this claim, you kind of have to dig into the workers' comp law and figure out who is responsible for the payment and et cetera, et cetera. You can't, it may be obvious in some cases, but it still has to be decided.
Look, we're not trying to run away from the fact that the claim involves the workers' comp law. If Ms. Davis was not an injured worker and she was just going to see a provider independent, then the provider might have a legitimate debt. So yes, I agree with you on that, Your Honor. But the question here is whether an executive branch agency is all of a sudden going to have adjudicatory jurisdiction to decide a dispute between Ms. Davis, the injured worker, and the provider.
And I think what the other side would say, though, and this was one of the issues I had with your brief, is that they're not saying that the department is going to decide a consumer protection action, an award in response to Justice Lawson's question, and apply that statute. They're basically saying that type of dispute just is not, because of the way the workers' comp system works, that in this context, this type of billing issue is off the table and has to be handled within the workers' comp framework.
But that's the problem with their argument, because if you look at everything else in 11C, Your Honor, they are deciding disputes. Everything else in 11C, overutilization, and this happens, and we put the forms in there for you to see. When the provider and the carrier don't agree on the billing, they go to this procedure that the department has set up. So it is an adjudicatory function, but it just doesn't have any room at all for the injured worker. So it's disingenuous to say that the purpose of this language is to somehow preclude Ms. Davis from an unjust enrichment claim or an FCCPA claim, when everything else under 11C is to actually allow carriers to contest if providers are overbilling, or providers to say we're not being paid enough. So everybody else gets to have a day in the department rather than court except the injured worker. And that's just not a reasonable reading of the any matters concerning reimbursement, especially as we've gone through in our brief. When you consider that reimbursement, you can look it up in multiple dictionaries, it's defined as indemnity. And indemnity inherent in that is that it's a three-party transaction. So there is a third-party requirement. It's intrinsic in the word.
I think it's pretty clear, though, in the workers' comp law that they kind of interchangeably use the word pay and reimbursement throughout the statute.
Your Honor, I agree, and that goes back to my hypothetical at the beginning. A reimbursement is a payment, but in this context that it's being used here, you're not collecting a reimbursement from the injured worker. It's payment being used in a different sense.
It seems different to me to have a situation where there's an argument about whether something should be covered under workers' compensation in the first instance, or even a dispute about the amount. In those cases, it seems like the statute where it goes to the agency and decided by a judge of compensation claims would correctly decide those type issues. But here, as I understand the facts, that the lab was put on notice that it was covered by workers' comp, blew past that, and sent, in these instances, for debt collection to a collection agency and threatened them with their credit being ruined if they didn't pay. That seems more squarely under the consumer protections statute. So it seems like those are different type scenarios, and what we have here is more properly under the consumer protection statute.
Yes, I agree. And there's and the two statutes, I would agree with Justice Lawson, they can be easily reconciled. If you give reimbursement the sense it's used 47 times in the statute, it's always used to talk about when a third party is paying a second party to compensate for something the second party either provided in terms of goods or services or paid. And the providers try to parse, like there's these different uses. There's not a single time in the statute that, I have it here, it's never used.
You're basically reading the statute as if it said, the department has exclusive jurisdiction to decide reimbursement disputes. See the defined term reimbursement dispute. And for better or worse, and who knows if it was intentional or not, that's not what the statute says.
I'm not reading the statute like that, Your Honor. I'm reading it for reimbursement matters. And while I get your point that you're not, and this is the point you made is not something the providers have argued up to this point, but there's a whole host of things that go under subsection 12. And the head of that panel is the chief financial officer. And that has to deal with setting the prices. So, and there's a footnote in the second DCA opinion that acknowledges this. You have reimbursement disputes between providers and carriers. That's one type of reimbursement matter. And then the chief financial officer and this panel, with the assistance of the department, sets the statewide schedules. And that's how the word reimbursement is used 31 times.
Right, but in section 12, I mean, that is not talking about the department. So, but to get to Justice Polston's point, it seems like what you're saying is that the jurisdictional question would turn on whether one of the elements of the claim is disputed or not. And that doesn't sound right.
I'm not saying that. I'm saying that, and I disagree with Your Honor to say that section 12 is not part of the department's purview. There's a three-member panel created that consists of the chief financial officer or his designee and 2 members to be appointed by the governor, subject to confirmation by the Senate. And then that panel determines statewide schedules of maximum reimbursement allowances.
Right. So where it talks about the department assisting and giving information to the panel, it's assisting itself.
The department, well, the chief financial officer, who's the head of the department, yes. And this panel that's within the department is my fair reading of this.
The providers are not. Jurisdictional question, though.
I'm sorry, I didn't hear you.
Justice Polston was talking to you about about this particular claim and the fact that it was uncontested, that that the bill was improperly sent and whatever. But that seems like it kind of would tie whether there's jurisdiction or not to whether in fact there's a dispute as to whether the bill was properly sent in the first place.
I don't agree, because the determination, if the JCC or there's some other, not every case is litigated, right? If there's some other determination that workers' comp benefits are available, then that will determine the issue. Now, if it turned out that Miss Davis, wasn't really an injured worker and she made it all up or something, well, then I guess we would be litigating that, but we'd still be litigating it in the court. I go back to the provider's argument would mean that providers could impersonate law enforcement and there'd be no remedy. Providers could use or threaten force or violence and there'd be no remedy.
Counsel, let me, when you mentioned the employee making it all up, would I be right in understanding the argument, your understanding of the argument that opposing counsel is making is that if you had circumstances where the employer made it all up, committed fraud, there's a fraudulent claim that is obviously related to claims for reimbursement, but it's all fraudulent, that would be a matter exclusively within the department's jurisdiction, and even though crimes were committed through perjured testimony or whatever else.
That is the natural endpoint for the provider's argument. Yes, Chief Justice. All those things would go to the department, and the department hasn't.
Well, the department can't really adjudicate those things.
No, they're not. If you go, they haven't filed a brief supporting this argument that the providers have made. I think if you were to call up the department and ask them this, they would be shocked to know that they're all of a sudden have all these things. They're certainly not equipped for it. What they're equipped to deal with is utilization and overbilling disputes between physicians and carriers.
What about what about the point made at page 24 and 25 of the initial brief here? This is the Einhorn point that we were talking about earlier, where as it happens, the statute, the workers' compensation statute, actually requires carriers to report instances of improper billing. Wouldn't that make this the kind of case where actually they do contemplate this being within their ambit? I mean, I see your thrust, the thrust of the argument that there's really no endpoint if we read the statute very broadly and say, well, what about a crime? What about? But don't we take from the rules in the code the fact that this type of dispute was precisely supposed to be brought to the attention of the department to mean something?
Right. So I don't deny that the department has investigatory powers, classic executive branch powers, and they can investigate these things. But that doesn't mean they have adjudicatory powers, which really goes to my last argument. If you accept this, the department has all three branches' powers. They get to write rules, they get to, which is making law, legislative, they get to enforce and do investigations, executive, and they have adjudicatory powers. And while we've greatly expanded since the New Deal what agencies can do, that seems like a bit much to me, and I don't think that's what the legislature intended. So everything you're saying, Justice Coriel, I agree the department can investigate. Just like if a provider committed some criminal activity that the Chief Justice just mentioned, well, then certainly you could call the state attorney's office too, and they would be able to investigate. But that doesn't mean that you don't have a private remedy for a battery or an assault. I see my time is running out. I didn't know if I was going to get any more, Mr. Chief Justice, but
we'll get a little more since the opposing counsel is going to get a little more.
Thank you. But I'm sorry, Justice Coriel, on the Einhorn case, that's Judge Bloom for the Southern District of Florida, a single judge. It's dealing with the Medicare statutes, and the language there, I think, is substantially
Yeah,
different.
no, it's a CF site though, and the structure of the argument though is the same, which is that if there's, you know, if there is a structure in the workers' comp law, as there is in the Medicare law, why shouldn't we understand that to communicate an intention on the part of, or not an intention, a meaning of the words that the legislature enacted, that this is a requirement that you use this dispute resolution mechanism. I guess that's the argument that I wanted
Yeah,
to.
I guess my response would be reread my answer brief, but the language matters. And the Einhorn case isn't talking about the statutory language here. It's talking about different language under the Medicare Act. And, you know, so I don't know what else to tell you other than reimbursement doesn't mean what the providers are saying. And it also doesn't make sense from the perspective that we're going to, it is giving the department adjudicatory authority over this dispute for something it's not equipped to deal with and doesn't deal with. You can't, if you read their forms, they won't allow Ms. Davis to file a petition in their dispute resolution process. So, yeah, I think to me, it's obvious that matters is reimbursement disputes and everything else under subsection 12, which isn't a dispute, that deals with setting the price. I don't know if that answers your question, Justice Coriel, but I just, different language matters, and I don't see how the language is similar here. I
mean, in 5D, they use the word reimbursement to talk about the employee wanting money from the carrier. So I don't understand, you keep saying language matters. I mean,
sure. So in 5D, that is the one slightly different wrinkle, but it's still being used in the context of indemnity. What's happening there is that the carrier can require the employee to reimburse the carrier for the payment it had to make to the IME for
it's a no-show
fee.
It's a no-show fee, but that's a classic meaning of reimbursement. Because the carrier pays it, and then the employee has to cough up part of it to reimburse the carrier for what the carrier has already paid.
And what? Right? Yes.
Well, actually, I think the 5D though, it's an odd placement for the sentence, but it seems to be going beyond just the no-show fee because they're talking about withholding payment. The employer or carrier withholding payment. They're not talking about the employee withholding the reimbursement.
Well, it's used twice, Justice Muniz. One, and I think I'm running out of time. One, it uses the word reimburse for the no-show fee. And then the second time it uses, and if I could just read this sentence, Chief Justice, and I'll conclude. The employee may appeal to a judge of compensation claims for reimbursement when the employer or carrier withholds payment in excess of the authority granted by this section. So the reimbursement there is obviously going to the provider, or there are a few instances where an employee, for example, if your first, this is getting in the weeds, but if you do your first exam and it hasn't been approved and you have to pay out of pocket, you can come back and get it. And there can be some things with pharmaceuticals, medical devices, but it's clearly talking about paying for the services or goods. And most importantly, it doesn't support that the department has jurisdiction. It says it's in a completely different agency.
All right, Counsel, if you go ahead and sum up in about 15 seconds.
We would ask the court to affirm the decision of the 2nd District, reversing the orders below that granted motions for judgment on pleadings. And thank you, all of you, for your time today.
Thank you, Counsel. Rebuttal.
Thank you, Mr. Chief Justice. I'd like to start with a couple of the points on which Mr. Gowdy and I agree. One of them is that we both agree that this claim only exists because of the workers' compensation law. That was the question of the series of questions that Justice Muniz asked. The gravamen of this claim is that the workers' compensation law was violated when a bill was sent to Ms. Davis rather than the carrier. That's the basis of this claim. The second thing on which Mr. Gowdy and I agree is that language does matter. So Justice Curiel, in response to your questions, if you look at subsection 11A of 440.13, one of the things that you are exactly right on this, one of the things that is specifically mentioned in that section is instances of improper billing. The department has the authority to investigate and monitor instances of improper billing. And that's why when I read the rules earlier, this is the language matters here too. The language of the rule 69L 34.003, a person like Ms. Davis may report a violation to the Office of Medical Services and, among other things, may attach the copies of collection letters that she received from the provider or the debt collector. There's really no clearer indication that that statute and instances of improper billing and the department's responsibility for it sits exactly within the context of this case.
So if
and I want to make a...
In this case, you had the workers' comp carriers actually paid the providers, and they're paid. But in spite of that, they improperly billed the patient, and when told that they shouldn't be billed that and it had been paid, they ignored that, sent them to a bill collection, threaten to destroy their credit, and in fact do that and destroy their credit. There's no other recourse except to go back to a state agency for the patient.
I think, Justice Polston, that the answer is the agency, there is recourse at the agency, but I want to make sure that means, I want to make sure you understand that doesn't mean there's no remedy. The agency has the power and the responsibility here. In that instance that you're talking about, it can impose substantial financial penalties on a provider. It can disqualify the provider from participating in any workers' compensation services from there on. It can refer the provider for licensing proceedings. There are actually very powerful penalties.
But there's no direct, but if I'm understanding the list of things you've gone through, there is no remedy, no direct remedy that will be of direct benefit to the person who has been injured.
No, and that's the last point, Mr. Chief Justice, that I wanted to make, which is that the workers' compensation law in this state is designed to be an efficient, self-contained apparatus. And one of the trade-offs that gets made, and you see this in the statement of legislative intent, is that employers and employees and carriers all give something up. There is a remedy here. It just doesn't flow directly to Ms. Davis.
You know, this whole argument about the purpose of workers' comp, I find mystifying, because I understand that this administrative process is set up to cut down on litigation of matters, disputes between the providers and the carriers over all those things that are within the scope of the statute. This is a dispute that arises from something that is expressly ruled out by the statute. Assuming that the facts in the complaint are true, it's something that's expressly outside the workers' compensation system. It's something that is prohibited. And so the idea that somehow this is going to protect vindicating your position protects the workers' compensation system, I think it's detached from the reality. So what am I missing when I think that?
I think, Mr. Chief Justice, what you're missing is that argument simply turns back on itself. As Mr. Gowdy conceded, the reason that this complaint was filed was because the provider improperly billed Ms. Davis rather than insurance carrier. So yes, the insurance carrier actually is supposed to handle those bills.
Counsel, the trade-offs, all the trade-offs you talk about when you're talking about the workers' compensation, that is not implicated in this alleged wrong done by the provider to this patient. I don't see how that is at all implicated by the trade-offs that are underlying the workers' comp system.
Mr. Chief Justice, my point was that this entire system, including the exclusive jurisdiction provision, is designed to capture all of those trade-offs in one self-executing, efficient system. Ms. Davis had recourse to the agency in order to bring a complaint, to get penalties assigned against these providers, to disqualify them from future workers' compensation proceedings, whatever in the case of all of these hypotheticals we're talking about would take place. But what Ms. Davis chose to do was something that is outside of the capability of the Article 5 courts of this state, which is to sue under the consumer collection laws. Ms. Davis had a recourse. The recourse was designed in a specific way. The statute makes sure that that recourse is exclusive within the department, and that's where this should stay. If there are no further questions.
All right. Thank you, counsel. We thank both of you for your arguments in this case. And that concludes this session of court.